association with the State Culture Department. Well, clearly time flies, which is why we did not realize that 2 days have already gone by where we witnessed some fascinating and insightful dialogue and deliberations from our authors and speakers. And here we are on the final day. Before we start with today's session, I would like to inform the members of the audience about the exhibitions, different kinds of exhibitions that are put up in different parts of Bharat Bhavan. At Rang Darshani, we have Rita Jhunjhunwala's exhibition titled Poetry as Art. At the forecourt in front of Tribal Art Gallery, an exhibition of vernacular gaunt paintings, an exhibition and demonstration by Radheshyam Kherwarji from Balaghat. Sorry. At Modern Art Gallery, we have the Permanent Hall of Masters. Permanent Adivasi art is put up at the Tribal Art Gallery. And next to the bookstore, we have two exhibitions, India Life Around Water, an exhibition by Dr. Sarah Keller, and an exhibition of projects by the National Institute of Design students. Do pay a visit. My understanding of constitutional morality is the adherence to the core principles of constitutional democracy, such as individual autonomy, liberty, equality, dignity, privacy, and non-discrimination in matters of personal choices and relations. But we have experts here who will correct me if I'm wrong and explain the idea in detail to us. I would like to invite our eminent guests here. To speak more on this idea, I would now invite eminent jurist Justice Madan B. Lokur, who's a judge of the Supreme Court of Fiji since 2019. He's former judge of the Supreme Court of India and also a former Chief Justice of the Andhra Pradesh High Court, the Guwahati High Court, and he's been a judge of the Delhi High Court. Welcome, sir. I would request you to grace the stage. The session will be moderated by Mr. Bishwajit Bhattacharyya, who's been a senior advocate of the Supreme Court of India, a visiting faculty at Indian Law Institute, and a country manager at ANZ Grindlays Bank. He's also a visiting professor at IIM Ahmedabad. As Additional Solicitor General of India, he's credited with winning several big revenue cases for the tax department, including a landmark case against Fiat India Automobiles, wherein the company had to pay close to rupees 432 crores as excise duty to the government. Sir, I would request you to grace the stage. Justice Madan B. Lokur and Mr. Bishwajit Bhattacharyya on constitutional morality. So we'll request you to begin the session. Yeah. The mic, sir.
Extremely honored and Justice Madan Lokur, as you know, is a human being first and an outstanding judge, in my view, in the history of India. In my view, you have never had such a great combination of a great human being and a great judge. He not only he is the first, he is the only judge of a Supreme Court of a foreign country. He is a sitting judge now from India only. And he has been an outstanding judge in the Supreme Court. He's been the Chief Justice of 3 different high courts, acting Chief Justice Delhi High Court, Chief Justice of Assam High Court, comprising of 7 different courts, and also the Chief Justice of Andhra High Court. And I am really honored and I feel greatly inspired. And I am Bishwajit Bhattacharyya. I am basically a lawyer and I have been a law officer of the Government of India. Thank you. So may I just request and ask Justice Madan Lokur to start. Constitutional morality. Morality is demarcating right from wrong. So what is your first comment as to what the country as a whole, in terms of constitutional democracy, where are we proceeding and where we should make better use of the constitution to make India even more vibrant and a democratic and a prosperous nation in terms of the founding fathers of the constitution.
Thank you, Bishwajit. The idea of constitutional morality was introduced in the Assembly to a Greek historian called Grote, who wrote about the democracy in Athens. And the view expressed by Dr. Ambedkar was that we are drafting a constitution, right? A constitution is a document of governance. You can't put everything in it. You can't say that this is the way you do this is the way you do that. All these things have to be done by the people who are in authority, who are in power, and they are the ones who have to, make the laws if necessary. Now, for example, recently there's been this controversy about the appointment of election commissioners. The Constitution says that the appointment of election commissioners will be done by enacting a law, right? The Constitution makers could have in the Constituent Assembly said that this is the way you appoint the election commissioners. But in a Constitution, you can't go into all these things. So they said you make, a law for this. Now, a law was not made for many years. A law has now been made, and there's been some controversy about that. I'll come to it a little later. But what Dr. Ambedkar had in mind was that there are certain things which cannot necessarily be said in the Constitution. And in spite of the fact that we have the longest constitution, but then we leave it to you, that is the people, to the legislators, to those who are in authority, to decide how to implement the constitution, how to have a good republic, a good democracy. And in that context, he said that constitutional morality is important, where you can have two different views, look at them, understand them, and then come out with a solution. Now, constitutional morality is different from popular morality. This is again something which was discussed by the courts. Now, I may think that something is immoral, right? That's my own personal opinion. A majority of people might think it is immoral. The majority of people might think something is moral, and what the minority is saying is wrong. It is not immoral. But that popular morality is different from constitutional morality. Constitutional morality, like I said, the Constitution is a document of governance. So you have persons who are in authority, a governor, for example, of a state. How is he supposed to act? What is he supposed to do? What are his duties? What are his responsibilities? You can't put it down, like a standard operating procedure, following 1, 2, 3, 4, 5, 6 are the duties of a governor. Election commission, free and fair elections. How do you have free and fair elections? You can't put it down, in black and white that this is the way it is supposed to be done. The speaker of the House or the speaker of the Vidhan Sabha, what are his duties? What are his responsibilities? This is where constitutional morality comes. The question to be asked is, what is the right thing to do? And this gets developed through conventions, through protocols over the years, and then that is the essence really of constitutional morality.
May I just ask you, Justice Lokur, as you have very correctly mentioned, the collegium to select the election commissioners, it has been replaced from the Chief Justice to a union cabinet minister. So you have three persons, the Prime Minister, a cabinet minister, and the leader of opposition. Does it not make the entire process, and does it not stultify Part 15 of the Constitution from Article 324 to 329, which says the superintendent's direction and control? It's completely stultified because whichever party may be in power, they will appoint their own persons, and so it will be at the best 2 versus 1 or 3-0. So does it not violate the grand norm and the very basis of the morality of the Constitution?
Yes, you're right. You see, it's like this. In the Constituent Assembly, there were debates about the Election Commission. And one of the questions that was raised was that why don't we decide how is the Election Commissioner to be appointed? Or the Chief Election Commissioner and the Election Commissioners, how should they be appointed? There were differing views. And Dr. Ambedkar said that, listen, this is going to take too long to decide what is the best way to do it. So let's leave it to Parliament. Let Parliament make a law on how to appoint the Chief Election Commissioner and the Election Commissioners. But the most important thing was that everybody in the Constituent Assembly said that the executive should not be involved in the appointment of the Chief Election Commissioner and the Election Commissioners. The executive should not be involved, which is to say that it has to be some independent body, because the executive is the one which is going to implement the law. It has to be some independent body. Free and fair elections is one of the basic features of our Constitution. So let's have some independent persons as the election commissioners. And they said that a law should be made. Now, Parliament did not make a law, right? There were some problems about the appointment of election commissioners. The matter came up to the Supreme Court. And the Supreme Court said that the Constitution requires a law to be made. Until a law is made, you should have a collegium of 3 persons. That is the Chief Justice of India, the Prime Minister, and another person, 3rd person, until the law is made. Now, a law was made. And in the law, what they have said is that it will be the Prime Minister, it will be the leader of the opposition. Instead of the Chief Justice of India, it will be a cabinet minister. Now, therefore, it is really the executive which is going to dominate. The Prime Minister is the head of the executive. A cabinet minister is a member of the executive. So therefore, what was intended by the Constituent Assembly, what was intended by everybody in the Constituent Assembly, including Dr. Ambedkar, that you keep the executive out of it. Through this law, the executive has been made the dominant body, dominant authority for the appointment of the election commissioner. So to that extent, Bishwajit, what you are saying is correct. It goes against the grain of constitutional morality, because the Constituent Assembly said have it independent from the executive, and today the law is not independent of the executive. I will just, give you an example. You have the Lokpal, for example. All right, the Lokpal is also appointed through a collegium. That's a collegium of 5 people. The Prime Minister is there, the Chief Justice of India is there, the leader of the opposition is there, an eminent jurist is there. So you have 5 people. So you have a precedent. Then you have the chairperson of the National Human Rights Commission. Again, you have a collegium of 5 judges, 5 people. So the idea of having 3 with the domination of the executive is really contrary to what has been happening in the past, namely the selection of the Lokpal, the selection of the chairperson of the National Human Rights Commission. So, in that sense, constitutional morality has been given a go-by through this legislation.
Sir, the matter is now pending in the highest court in the country, and the highest, whatever law highest court declares under Article 141 is binding, and all authorities, judicial and civil, under Article 144 shall aid. So while we have every hope that our apex court will rise to the occasion and protect this, the most basic doctrine of separation of power, some concerns remain, sir, like allocation of cases. Power corrupts, and absolute power corrupts absolutely. So under these circumstances, as the master of roster, sir, you have yourself been the master of rosters in 3 different high courts, and in the collegium for the whole of 2017 and whole of 2018, I recall. I mean, how a court, the apex court, which has now 34 judges, and the entire power is concentrated on one individual, that is the Chief Justice of India. And so there is so much of, if I may say so, uncertainty. Why the entire court can't be involved in this process? Your view, sir.
Yes, Bishwajit. You see, the concept of master of the roster, which is a phrase which has been used fairly frequently. What it implies, I mean, for those particularly the students who may not be aware of this, you see, in every court, that is a constitutional court such as the High Court or the Supreme Court, cases are allocated by the Chief Justice. So, and he's called the master of the roster. So he will decide, which case or which kind of cases will go to which judge. So in the High Court, you may have 40 judges, you may have 60 judges. Allahabad High Court has got something like 90 judges. So how do you distribute the work to the judges? That is decided by the Chief Justice, of course, with the assistance of the registry, and he decides that, all right, these 2 judges will sit in a division bench of 2 judges. This judge will sit as a single judge. These 2 judges will sit in a division bench. That judge will sit as a single judge, and so on. That's the job of the Chief Justice, which is the master of the roster. So having decided, which judge is going to sit as a single judge, which judges are going to sit in a division bench of 2 judges, then is the distribution of work. Now, in the high courts, what they do is they say that the Chief Justice says that, all right, criminal cases will go to, the following single judges and to the following division benches. Cases pertaining to taxation, for example, revenue, excise, income tax, GST, whatever, will go to the following single judge and to the following division bench. Civil cases, right, he will decide on the distribution. Now, the Chief Justice actually, takes into consideration the requirement of the court, number 1, in terms of numbers. Should we have 10 judges in criminal cases or 5 judges? If there are a lot of criminal cases, then he will decide to have 20 judges or 15 judges, whatever. So, one is the selection of judges. The second is the assignment of the roster. You will do the kind of cases. Now, as luck would have it, the Chief Justice will, of course, in consultation with the registry and in consultation with the judges, fix up a roster. Come across any situation except one particular situation in some high court. I have not come across any situation in any high court where this problem about the allocation cases. But unfortunately, in the Supreme Court, it has become a bit of a problem. This system is working perfectly well in the High Courts. I don't see why it should not work equally well in the Supreme Court. Now, in the Supreme Court, again, it's the same thing. I mean, the Chief Justice of India is normally a person who has been the Chief Justice of some High Court. So, experience of, the allocation of cases, he has the experience of who to put where. In court, we don't have a system of all of them are division benches. So you have 2 judges or 3 judges. And for constitutional matters, 5 judges. So this is justice. But then for some reason, the past, there has been, some sensitive cases going to a particular judge. And that is a bit of a problem, I mean, all judges, that one judge is better than the other, they're all equal. So why should some kind of cases go only to a particular judge who also does not happen to be a senior judge, who happens to be a junior judge? Why should the cases go to that person? Now that created a bit of a problem, so that problem unfortunately is persisting. And the perception is that cases that are sensitive are going only to a particular judge or a particular set of judges and not to others. And that, creates a problem. That perception creates a problem. That why is the master of the roster, that is the Chief Justice, why is the Chief Justice doing this? That creates a problem. Now, arbitrariness is antithetic, is the antithesis of equality. If all judges are equal, you cannot arbitrarily say that, well, certain kind of cases will go to a particular judge and to nobody else. That creates a problem. And that is why there is this controversy whether the master of the roster is exercising his authority or his responsibility or his power in an equal manner. Right? That is what is really the problem.
So thank you for being so very fair and candid, which you have always been. Another concern in this context remains, sir, in the collegium system. This NJAC verdict came on 16th of October 2015 by the Constitution Bench. Now from 2015 to 2024, this is the 9th year running. But there is a problem within the collegium, and there is also a problem of collegium's recommendations not being implemented by the executives. Now, should it not, if this situation persists for a long time, should it not create some kind of a constitutional immorality?
Yeah. You see, again, now, like I said in the beginning, the Constitution cannot have everything written down. It can't be a standard operating procedure sort of a document. So conventions have to be built up, and those conventions have to be followed. That is what is the essence of constitutional morality. Now, you have the collegium system for appointment of judges. It works at 2 levels. One is at the High Court level, you have a collegium of judges, that is the Chief Justice and the 2 senior most judges. They will say that, all right, we think that a particular person should be appointed as a judge of the High Court. 1, 2, 3, 5, whatever. So they make a recommendation to the government to say that, we think that this person should be appointed as a judge of the High Court. That is the collegium of the High Court. Now, the recommendation goes to the governor of the state. It goes to the chief minister of the state. They carry out their own, assessment. The chief minister, for example, may want to find out from the police if there's any case pending against that person, what kind of a character is that person, integrity and so on. And, they give their recommendation, yes, we think this person should be appointed, or we think this person should not be appointed, whatever their recommendation. And it goes to the Government of India. The Government of India also carries out its own assessment. They have the Intelligence Bureau. So the Intelligence Bureau will carry out its own assessment and say that, yeah, this person is a person of integrity, or this person, there is some problem about him. They make their own assessment, and they give it to the Collegium of the Supreme Court. Now, the Supreme Court Collegium consists of the Chief Justice of India and the two senior-most judges. They look at the entire record, right? What has the High Court Collegium said? What has the Governor of the state said? What has the Chief Minister said? What has the Government of India said? What is our view? If it is of a particular High Court, say High Court A, are there judges in the Supreme Court who have worked as judges in High Court A? Some of them may have been the Chief Justice of that High Court, some of them may have been judges. So they take their opinion and say that, please give us your opinion. And then the Collegium takes a decision. And the Collegium says that, yes, we are recommending this person and we think the recommendation is good. It is sent to the government. Now, again, how do you do that? There's no written document, but you have the entire record. What is the government supposed to do? The government is expected to say that, well, it's a recommendation that has come right down the line from the Supreme Court, we accept it. Or if they have any objection, they should say that, we have an objection. If you remember, we had told you that the Intelligence Bureau report said such and such a thing, please have a look into it again. And then the Collegium says, well, all right, you have told us that, you've reminded us about it, we'll have a look at it again. And they say that we've considered it, but we still think this person should be appointed. The problem arises now in the sense of constitutional morality. Should the government accept that recommendation or not? The problem that has been arising in the recent past is that the government says that, well, you've made a recommendation, we are not going to act upon it. And they sit on the file for a year, in some cases for 2 years. Even though the Supreme Court Collegium has said that, no, this person should be appointed. We have seen your objections, we do not agree with your objections. It is our view which we reiterate that you please appoint this person, and yet the government says, no, we are not going to appoint that person. That's where constitutional morality comes in. Now, if there was a law, for example, everybody would be bound by that law. But constitutional morality works basically on conventions, on principles. What is the right thing to do? Can the government say that, well, we don't agree with you. Is that the right thing to do? Why do you have this entire chain? Can the government, tell the Supreme Court that, we don't care for your opinion? That's where constitutional morality comes in. And that's where we have this problem, where appointment of judges is being held up for years together. And it could be for a frivolous reason. Now, there is a person who has been recommended for the judge of Delhi High Court. The government, again, nobody knows, but the perception is that the government is saying, we are not going to appoint this person because he's gay. Now, if he's gay, does it mean that he can't be a judge? A gay person can't be a judge. Is there some connection between the sexual orientation of a person and being able to, give justice? So this is where the problem comes in, and this is where issues of constitutional morality come in, where you can't have everything written down in black and white like a standard operating procedure. You have conventions, you have protocols, which are built up over the years, and act upon those, because that is the right thing to do.
Sir, governors of states are sitting over bills passed by the states. for years and for months. Does it also not amount to constitutional immorality?
Yeah, that's a very good question, yes. What are the governors doing? The legislature passes, the Vidhan Sabha passes a law. What can the governor do? The governor can say that, listen, I think this law is unconstitutional. These are my reasons. And I'm sending it back to you for reconsideration. You please have a look into it. If you agree with me, fine. If you don't, that's entirely up to you. Or he can say that, well, you know, it's going to be in conflict with a law enacted by Parliament. So, this is my view as the governor. So, I'm sending it to the President to examine it. And the President of India will decide whether there's a conflict between the law that has been made by the Vidhan Sabha and the law that has been made by Parliament. The third thing that the governor can do is say, yes, I agree, you know, and I give my assent to the bill. The President does that. In this recent session of Lok Sabha, several bills were passed. The President gave her assent. Now, what has been happening is that the governor has been sitting over these bills and saying that I'm not going to do anything, you know. I'm not going to tell you it's unconstitutional. I'm not going to say it's contrary to the law enacted by Parliament. I'm not going to say yes. I'm not going to say no. I'm going to do nothing. That is not constitutional morality. Because the Constitution requires that, you know, you have to take a decision. The Constitution does not say, again, standard operating procedure. Constitution does not say that you have to give your opinion within 10 days or within 15 days. The Constitution says that you have to take a view within a reasonable period of time. What is a reasonable period of time? A reasonable period of time is something that you and I would generally agree with. You know, in a given case, it could be 10 days. In a given case, it could be 1 month. But it could never be 1 year. Right? It could never be 2 years. Now here, the governor says, well, I'm sitting over it and I've been sitting over it for the last 1 year. What are you going to do about it? That's not constitutional morality. You have to decide within a reasonable period of time. Take a month. Okay, take a month and a half. But take a decision. You can't say, I'm not going to take a decision. That's not constitutional morality. We've had instances of this nature in the recent past. So some of the state governments have gone to the Supreme Court and said, what is the governor doing? You know, please have the governor take a decision. So what does the governor do in a particular case? He says, all right, I've been sitting over it for the last 2 years. Now I'm going to send it to the President. Now, if you had wanted to send it to the President, why didn't you do it in the first instance? And why have you sent it to the President? Is there a conflict? If there is no conflict, why have you sent it? And if there is a conflict, why have you not written about the conflict? Say that this is what Parliament says, this is what the Vidhan Sabha says. I think there is this conflict. And therefore, Madam President, please resolve the conflict. The governor in these cases has just said, I'm sending it. That's not constitutional morality. You have the Speaker of the Vidhan Sabha, implementation of the anti-defection law, the 10th schedule to the Constitution, where people have switched allegiance from the party on which they were elected. A petition is filed before the Speaker saying that this person should be disqualified because it's a violation of the 10th schedule. And the Speaker says, I'm not deciding. Now what do? That's not constitutional morality. The law doesn't say, the Constitution doesn't say you have to decide within 10 days, or you have to decide within a month, or you have to decide within 6 months. It doesn't say that. Again, reasonable time. Now, what is reasonable time in a situation like this, you know, where a person deserts his party from which he got elected and joins another party? The 10th schedule, decide it within a week, 10 days, 15 days, hear the parties, take a call and say that, well, you know, what you've done is wrong, or what you've done is right. I don't see anything illegal in this. But the Speaker cannot say, I will just sit down and do nothing. And that's what's happened. In one particular case, the people went to the Supreme Court and said that, why is the Speaker not taking a decision? So the Supreme Court said, you please decide, and decide quickly. Speaker said, okay, you say decide quickly, I will decide when I feel like deciding it. I'm not going to decide it now. So these people went back to the Supreme Court and said, listen, in spite of your saying so, he's not deciding it. So the Supreme Court said, I'm giving you 3 months. Please decide within 3 months. 3 months, I think the Supreme Court said, is a reasonable period of time. Fine. Then the Speaker took a decision. Right? We had the same problem recently in Maharashtra, where a decision was not being taken. That's not constitutional morality. If there was a law which says that you decide within 10 days, fine, follow the law, but like I said, the Constitution cannot say all this. You know, reasonable time, what is reasonable time? Can I decide it at 2 o'clock in the morning? I mean, you know, you have to be pragmatic. You have to look at the Constitution as a document of governance, not as a document of misgovernance or non-governance.
Justice Lokur, PILs are being preferred to remedy these situations, and PILs, of course, have been triggered by many. What is your overall view? Has the concept of PIL, which are being filed and triggered, have they really achieved the purpose, or a lot leaves to be desired?
Yes. You know, I think public interest litigation, PILs, are a very strong weapon in the hands of the people to have the courts deliver justice. I will tell you about the first, 2 or 3 cases. One is about bonded labor. Okay, bonded labor is something horrible. What happens is, because of a bad year, crop or something or the other, somebody borrows money from a money lender. Money lender says, I'm going to take, 24% interest or some 50% interest or something, and the person is never able to pay the, repay the loan. So he works for that money lender, or whomever the money lender says that you work for that person, to try and, give that loan. He can't do it in his lifetime, so his children have to do that work. They can't do it in their lifetime, so their children have to do that work. So 2 or 3 generations get lost in this idea of bonded labor. And the Supreme Court said it is, despicable. Now, the law says, the Constitution of India says that there will be no bonded labor. There is also a law which prohibits bonded labor, but yet there have been bonded laborers. So Swami Agnivesh sent a letter to the Supreme Court, which was in the nature of which the Supreme Court treated as a public interest litigation. It was a letter sent by him saying that, listen, right next to Delhi, in Faridabad, there is bonded labor. Can you do something about it? Now, 2 questions arose. What about those bonded labor? Could they not have come to the Supreme Court? How could they have come? They don't have the money, right? They're probably repaying the loan of their father or their grandfather. They don't have the money. They're illiterate. How can they come to the Supreme Court, engage a lawyer, spend money, file a petition? So the Supreme Court said that in a situation like this, where social justice demands that a letter should be treated as a petition, we will treat it as a petition, public interest litigation. And they passed orders saying that bonded labor is unconstitutional, so therefore these people should be given freedom. Second case, in Bhagalpur, the police rounded up some people who they said were criminals. They may or they may not have been criminals, I don't know. But they, put needles in their eyes. They put acid in their eyes, made them blind. There's a movie called, I think, Ganga Jal. Ganga Jal movie is based on this. Now, It came out in the newspapers. That newspaper report was treated as a public interest litigation. Again, the question, why couldn't these people come to the Supreme Court? They don't have the money. They're in Bhagalpur. They've been blinded, okay, tortured by the police. How can they come? Again, a newspaper report and a letter. Supreme Court said, we will treat this as a public interest litigation and social justice. They said that the state has done something illegal. They should, pay for the treatment of these persons. Even if they're criminals, so what? You can't put acid in a person's eyes just because he happens to be a criminal. This is how public interest litigation developed. There was one about the environment, there's one about corruption and so on and so forth. So public interest litigation really is the people telling the government through the instrumentality of the court that what you are doing is wrong. It is not in public interest. You cannot have bonded labor. It is not in public interest. You cannot blind people, put acid in their eyes. It is not in public interest. You cannot, take no action against corruption. It is not in public interest. So many of these cases, of course, there has been some misuse. I'm not saying there has never been any misuse. There has been some misuse of public interest litigation. But then the court finds out, that you're misusing the judicial process. So public interest litigation really, I think, is a very, very strong weapon for a common citizen of this country to tell the government what you are doing is wrong. It is not in accordance with the Constitution. It is not in accordance with the law. It is not in accordance with the constitutional morality. And therefore, please do the right thing. Try and imagine somebody, Bhopal is also quite far off from Delhi in that sense, but try and imagine somebody from the northeast, Meghalaya. Something is happening over there. How is he going to come to the Supreme Court? He doesn't have the money. Maybe he is illiterate. Somebody down south, Andaman Islands. How is somebody from Andaman Islands going to come to the Supreme Court? So public interest litigation is a very, very strong weapon of social justice. And it is intended to tell the court that what you are doing is not in public interest. I had to deal with a case where, laborers under the Manrega, the Mahatma Gandhi National Employment, Rural Employment Guarantee Scheme, were not being paid. So they were doing work, but not being paid. Why? Does constitutional morality say that, you ask a person to do work and not pay him? Begar is unconstitutional. It's there in our chapter on fundamental rights, that there shall be no begar. Now here you have people who are doing work under Manrega, not being paid. Is that social justice? Is that constitutional morality? It is not. So we said that please pay them. Now the other thing involved in Manrega is that if the payment is not made within 15 days, they're entitled to interest. Okay, so most of these people said, listen, just give us our money, if interest is not being given to us, doesn't matter, but at least give us our money. That's where constitutional morality comes in. That you have to give them their wages, you have to give them their interest if you don't give them their money on time. Again, the law doesn't say that, listen, you have to open a bank account, you have to do this, you have to do that. There's no SOP for that. But that is how the law is to be implemented. That is constitutional morality again.
Sir, my last question, and then this distinguished audience, I'm sure they will be asking questions to you directly. My last question is, with enormous amount of pendency, it's mind-boggling. It's scary. You go to a court, by the time the case is decided, either you maybe know more, or you may turn out to be a pauper by legal expenses. So, how do you foresee our country can overcome this mammoth crisis?
Yes, Bishwajit, we have a huge problem. It's a huge problem of more than 50 million cases pending in our country. 5 crores, more than 5 crore cases are pending in our country. Right now, there's a judicial officers conference going on in Bhopal. Yesterday, the Chief Justice of Madhya Pradesh, this is what I read in the newspapers, said that recently he decided a case, or the Madhya Pradesh High Court decided a case that was 60 years old. Okay, now I don't know if the person who was a litigant, if he was 20 years old, he gets a decision when he's 80 years old, provided he survives to the age of 80, otherwise his children get it. So, delays are fatal in some cases, where you don't get justice, which is one of the key words in our preamble. Justice is right there, social, economic, political. A person doesn't get justice, but his children get justice. Sometimes even the children don't get justice, the grandchildren get justice. So we have a huge problem, and I believe that all our judges must take it up, on a war footing, so to speak, to ensure that, these cases get decided quickly. Many of them, I can tell you from experience, many of the cases are completely dead. There's probably nothing in it. I remember when I was in the Delhi High Court, I was doing, landlord-tenant disputes. And in many of those cases, many of those cases, what had happened was that either the landlord had sold off the property to the tenant, or the tenant had left the property and gone to some other place. But the case was still pending. Now, if that exercise is done, which is something that the registry did, something which I did, we finished off all those, pending cases. So it is not a problem that is insurmountable. I think it is a problem that can be tackled, but there has to be a will to do it. There has to be a determination that 50 million is too much. We must give justice to the people within a year. In some cases, all right, 2 years, if it's a very complicated case, but not after 60 years, not after 10 years. So, like I said, this problem is not insurmountable, but you need that will, that I am going to do it. And if you take that decision, I'm sure the pendency will come down.
Thank you. I now respectfully invite, yes, please.
I'm Raghav Chandra, a retired IS officer and the director of the BLF. So my question to you is about the collegium system. We've had very, differing views, and recently Chief Justice, also a former Supreme Court judge who has just retired, has said that not everything is okay with the collegium system. And we do have instances of younger junior judges getting promoted directly to the Supreme Court, sometimes a very senior judges not getting promoted in time, even though they're meritorious. And you yourself have mentioned a case or two. What really is your take on it, and how do you, the NJAC system, for instance, which was proposed to be there, which was meant to resolve and reform all this, how could that have made a difference, and what really should have been done?
Yeah, thank you, Raghav. You see, the problem with the National Judicial Appointments Commission, which came in through an amendment to the Constitution, and also there was a law based on that amendment. All of us felt that it impinged on the independence of the judiciary. Now, an independent judiciary is one of the essential basic features of the Constitution. You can't have a judge who's dishonest, right? Or in a cricket match, for example, you can't have an umpire who's, all the time deciding in favor of one particular team. Or in a football match, a referee who's always deciding in favor of one particular team. Similarly, you can't have, judges who are dishonest. It's completely antithetical. So, if there is any attempt to control the independence of the judiciary, it is an attempt to go against the essential feature or the basic structure of the Constitution. And that was the reason why the National Judicial Appointments Commission was struck down by the Supreme Court. Now, the present system of appointment of judges under the collegium system is not perfect, okay? And the government has shown that it is not perfect because they are not accepting the recommendations of the Supreme Court. So it is not perfect. How do you get the government to accept the recommendations? That is one. Number two, how do you get the Supreme Court to give the right recommendation? They may give a wrong recommendation, That has also happened. How do you prevent that? Now, no system of appointment, no system of election can be perfect. Over a period of time, maybe after 10 years, 15 years, 20 years, it might become perfect, or semi-perfect, or almost perfect. But there are bound to be some gaps somewhere. The idea is to minimize those gaps. If there are 10 gaps, bring it down to 1, bring it down to 2, and then maybe next year bring it down to 1. Now, we had suggested, when I was in the collegium, I had suggested to my Chief Justice, and other judges had also suggested some reforms in the collegium system which were implemented. Some were not. So, this is a process that is evolving, okay? Earlier, reasons were not being given. Now, reasons are being given. Somebody said that, let's give reasons why we are rejecting a person. We felt, why should we give a reason why we are rejecting a person? It's going to harm his reputation. Why should we do that? So, this thing is evolving. It will take some time to settle, but there has to be cooperation between the Supreme Court and the government. The government cannot say that, listen, what we say is final. Because conventionally, at least since the 1990s, what the Supreme Court says is final. Why should the government now turn around and say that, no, you see, what I say is final. So if I don't want a person who's who's gay to be appointed as a judge, he will not be appointed. Now, again, you bring in the question of constitutional morality. Does the law say, does the Constitution of India say that a gay person cannot be a judge? It doesn't say anything like that. So, really, to answer your question in short, it is an evolving process. It will take some time to settle down, but both the government and the Supreme Court judges have to realize that there has to be some give and take. Without, that give and take should be without compromising on the independence of the judiciary. Otherwise, you will have every decision being taken in favor of the government and no decision being taken in favor of the citizen. If that happens, we are in deep trouble. Okay.
Thank you. Now, lots of hands I can see. Yes, please.
Hello. Good afternoon, sir. Good afternoon, sir.
Yes, the lady first.
Thank you. Thank you very much. A very good morning to both of you, everyone here.
Can you keep the mic closer?
Yeah. Your insights were very useful for us. I have two questions. One larger question which has two components in it. So my question is related to the emerging trend of on-the-spot justice in India, which we are seeing in our day-to-day newspaper readings. We have two examples of it also. The Hyderabad rape case, in which police directly shooted the culprits there. All those results, and the second case is related to the various encounters that took place when the hearing was going on in the courts So the state machinery did those encounters by saying that there was something. So my question is how this is going to negatively impact the overall court and its procedures, because the providing justice is providing justice is the work of the courts in India, and if the state will start doing this, it somehow will reduce the what should I say, the image of the courts in India. And second is related to the bulldozer justice in India, which is taking place very rampantly in northern India specifically. So my question is related to these things, the on-the-spot justice which is taking place, which is being executed by the government in India. So how you see as a judge, if the state will start imparting justice on the roads, how it is going to negatively impact the courts and the rule of law in India? Yeah, thank you.
Yeah. You see, this idea of instant justice is wrong. Okay, let's be absolutely clear about it. What happened in Hyderabad, where those 4 persons were alleged to have raped some doctor, and there was a sort of an encounter. The Supreme Court appointed a committee. The committee has found, after going through the entire record, talking to everybody, that the encounter was fake, right? Nothing like what the police said had happened, but the police said they were trying to run away, so we just shot them. That's wrong. That's instant justice. The problem really arises that if the state gets involved in this kind of instant justice, the message down the line is terrible. You would have read a couple of days ago in the newspapers about an interfaith couple in Karnataka. All right? They were staying in a hotel room, and some 6, 7 people just barged in and beat them up. Okay, and made a video recording of beating up these people. They took the law in their own hands. They said that we think, we are against interfaith relationships. All right? Now, first of all, that is wrong. I mean, there's nothing in the Constitution of India which says that there cannot be interfaith relationships. And secondly, they took the law into their own hands. So, if you tie this up along with, the issue of constitutional morality which we are discussing, where if the state is not able to implement the constitutional provisions, the people will take the law into their own hands. You've had so many lynchings that have taken place, right? Somebody is accused of, something or the other, and a mob comes and kills him. That's not justice. There's no way that you can call that justice. Now, if you're able to do this, if you're able to dispense justice in the courts within a reasonable period of time, then these kind of instances will not happen. That is why, the question that was asked about a large number of pending cases is very, very important. You've had very complex cases, the attack on Parliament, for example. That was decided within a period of 9 months by the trial court, and then again in appeal within 6 months. You've had the trial of this 2611 Ajmal Kasab, decided quickly. Complex case. Now, if these cases can be decided quickly, why can't other cases be decided quickly? If other cases can be decided quickly, you will not have 50 million cases pending. If you don't have 50 million cases, but you have a reasonable number of cases pending, issues of instant justice will not be there. Okay, I hope that answers your question.
Yes, please.
Hello, good afternoon, sir. I am Prince Gupta and I am a student of law. Sir, I have a question in regards to constitutional morality in the context of Sabrimala case, wherein you see constitutional bench of Supreme Court giving a particular verdict and the majoritarian morality not ready to accept the same. So how do you see there is any synthesis or balance between these two things? And my second question is regarding
Check, hey, check, hey, check.
one of the justices has been appointed as a member of parliament in Rajya Sabha, another being appointed.
Check, hey. Check, hey, check, hey, check.
Sabrimala judgment is concerned, Now, we are in a minority in that sense. And we can then prevent the election of people. And we can then destroy the institution of parliament. Because in a parliament of 540 members of parliament, only 20 will get elected, or only 50 will get elected. What kind of a parliament is that? So therefore, the views of the minority, whether it is, religious minority or whether it is some other kind of minority, has to be respected. And that is really the essence of constitutional morality, where you take in the views of everybody. You take a decision. I mean, nobody is stopping you from taking a decision. But don't take a decision because I think I'm in the majority, so therefore whatever I say is right. I may be wrong. And then the minority can then create a problem. Okay? So this constitutional morality recognizes dissent, recognizes disagreement, but there's also constitutional morality in that minority. They can't say that because we are in a minority, therefore we will do whatever we feel like doing. No. Constitutional morality applies to them also, and Dr. Ambedkar made that pretty clear. Okay, I didn't get the second question.
Current question. We are 12 minutes past 12, so this is the last question because next session is waiting.
Yeah.
This is the last question.
Okay, can I answer that separately then? What is your question? Yeah, that's...
Rajya Sabha member.
Yeah, well, times have changed. Times have changed. Let me tell you, we've had a very, very eminent Chief Justice of Bombay, Mr. M.C. Chagla, appointed as a union minister, right? Nobody said anything. Okay. Dr. Rajendra Prasad in the Constituent Assembly talks about people of character and integrity. He says if we have people of character and integrity, nothing will go wrong.
So true.
You had people of character and integrity. That's why a person like M.C. Chagla was not only a union minister, but also I think he was the High Commissioner to England. Okay, a judge. But things have changed since then. So if you have somebody appointed as a member of the Rajya Sabha, people are going to raise fingers. If you have judges appointed as governors, people are going to raise fingers. They're going to ask questions, which they would not have asked 40 years ago, 50 years ago, 60 years ago. So times are changing, and we need to get people of character and integrity back into our system. Yeah.
Okay.
Thank you.
Thank you very much.
Hello.
Thank you very much. And really, it was a great honor for me and for all of us to be here. Thank you, Sir Justice Lokur, for outstanding and scintillating your views. Thank you.
Absolutely.
Yeah, thank you. Thank you very much.
Thank you so much, Justice Lokur and Mr. Bhattacharya, for this candid and powerful conversation, which was so refreshing. And Justice Lokur, as he rightly said, that what's the right thing to do, whether it is about the governor's role or lawyer Saurabh Kirpal. So thank you so much for this. And it was definitely a scintillating session, which is why we had so many questions from the audience. I would now request Brigadier Sanjay Agarwal, member of the Society for Culture and Environment, to come on stage and present a token of our appreciation and gratitude to Justice Lokur and Mr. Bhattacharya. Justice Lokur, Judge of the Supreme Court of Fiji since 2019, former Judge of the Supreme Court of India. Mr. Bishwajit Bhattacharya, an eminent lawyer and a visiting faculty at many top colleges of the country. So this is a Gond painting by a senior-most Gond artist, the memento that you have. It's also the mascot of BLF 2024. It's a painting made by senior-most Gond artist Ram Singh Urveti ji. Thank you. I'm glad you like it, sir.
Thank you.